Hi, we're talking about Your Money Matters on NDTV Profit, and my name is Alex Matthew. Now, when it comes to money and inheritance, there's a lot that comes into play from a legal standpoint. So the question that we're asking today is what happens when you have joint ownership of something? And it can be anything from a savings bank account to a fixed deposit to a demat account to maybe a house or a parcel of land. What happens after your demise, or what happens if you are the survivor? Do you automatically claim ownership of what remains? That's an important question to ask. And joining me to talk about what the law states is Bijal Ajinkya, who's the partner at Khaitan Co. Bijal, thanks so much for taking the time, and good evening to you.
Good evening.
So let me start by asking about first financial assets, and then we can talk about physical assets, if it works that way. So starting from the simple savings bank account, first of all, a lot of people go through this period of turmoil, and oftentimes it's not really a planned thing. That's just the nature of how these things work. So what occurs? What is the legal standpoint?
Sure. Thanks, Alex. So what is important to note is that on ownership, India follows the British model, which is with respect to tenancy in common and joint tenancy. Now, very often when you have a savings bank account, you may write, say, two people as the owners, or, the account is in the name of two people. Now, technically so, you will never really provide any banking instruction to say that, between A and B, who are owners of that particular savings bank account, their ratio or their ownership in that bank account is of X and Y ratio. Now, in a situation where nothing is mentioned and no one really disputes the ownership, it is deemed to be 50-50. And to that extent, when A passes away, whatever is the account balance, A can, in his or her will, essentially have the entire succession move accordingly. However, there have been enough and more situations where, in a case where, let's assume A's heirs do not really make any claim on that particular bank account, to that extent, it would be considered as a joint tenancy, wherein B just becomes the owner of that balance in that bank account. What is important to note is that the default rule, unless somebody tries to argue to the contrary, will be considered as 50-50. And to that extent, even if a nomination or a nominee is mentioned in the savings bank account, it does not mean that the nominee has any sort of stake. A nominee is only acting as a trustee who needs to take care as a caregiver to that particular property until the time the real heirs or the owner actually makes a claim on that particular property. So
Important.
that's it.
I do want to ask about this though. When you go to open a bank account, and of course, I think some of us come from a generation where you actually had to go to the bank to create an account. Now it happens online, right? But you're asked either or survivor in case you're making an account. So what does that mean in the context of what we just spoke about?
Excellent question. Very, very important to note that either or survivor are only operating instructions. It has nothing to do with ownership per se. So the owners of the account can be, say, A and B, and I may essentially provide for an operating instruction that either A or B can actually operate it, which is either or I can essentially say only the survivor, which essentially means it is first A because his or her name is the first person in the account, and only after A can B actually start operating that account, which is either or survivor. So it's only vis-a-vis operating instructions. Either or survivor has absolutely no play in the ownership of the bank account as such.
Important clarification. And so therefore, just to round up this bank account situation, and I'm guessing the same is true for a fixed deposit because it's an extension, it's ultimately an account, right? But the question is there a threshold for amount in the bank where the bank will ask no questions and you go to the bank and say, my owner of this bank account has passed away and I would like to claim full ownership? Is there a threshold, or is there no such thing?
So law does not provide any threshold, neither has any judicial authority really provided any threshold. However, banks, for their own compliance reasons, may have an internal threshold, of course, depending on the bank, depending on the account, to say that if at all the account balance is above a particular limit, then in that situation, if they do know of one of the owners has passed away, they may insist on a probate or a succession certificate or a letters of administration for the other party to really operate that account if they do know of that person's demise. So to that extent, law does not provide any threshold. However, every bank does have its internal thresholds wherein if they know of the person's demise, they will essentially see whether it crosses the threshold. And only once there is a clarity on who the real heir is, will they allow the other joint owner or essentially the nominee to really operate the account in itself.
Okay. Now, in a situation where there can be a contesting of the ownership, where, let's say, it's 50-50, right? What you said, the default is 50-50.
Yes.
The claim can only be made for 50%, right? In this situation, because
that is correct.
Right. So
that is correct.
So just to ensure that I'm right in my thinking. Ordinarily, if there is not a large amount, then the bank will not necessarily ask too many questions. But if it's crossed a certain threshold, and this depends bank to bank, then you might have to furnish certain details. In the absence of a will, what do you do?
In the absence of a will, you would essentially look at the succession law, which applies to the deceased. And succession law in India really depends on the religion which you are born to. And to that extent, if a person is a Hindu, it would be the Hindu succession law. If it's, a Parsi, it would be the Parsi succession law, and so on and so forth. So you would look at the, rule in a situation where there is no will. You would look at the default provision under the succession law in itself to see who the real successors or the heirs are.
And do the rules change for demat accounts and mutual fund units?
So the rule does not really change. What is important to note is that, SEBI as well as the stock exchange and the regulator found it extremely difficult in situations where you just have a single owner and you mentioned a nominee. Now, obviously, a securities, depository participant or any securities regulator cannot have a situation where there is no person who actually is the owner of a particular demat account or, for that matter, a mutual fund. And therefore, to just identify who that person is who is essentially taking decisions and who they can really take banking instructions or instructions on dealing with securities, the law has been clarified by way of the SEBI issuing a circular to essentially say that from a securities perspective, when the first owner passes, they will automatically transfer the proceeds or allow the second holder really to operate that particular securities account. Important to note that SEBI cannot really carve out what the law is vis-a-vis succession, because you do have a succession law to that. So to that extent, when SEBI has provided this circular, it only means that from their perspective, because they cannot have a securities account without a named person, from their perspective, they would look at the second holder, or in the situation where there is no second holder, they would look as the nominee as the person who that particular securities account really, is held in. However, it would be for the heirs of the deceased to really get your succession certificate, or for that matter, your probate, and go and tell the depository participant or the mutual fund, for that matter, that this particular, demat account or this fixed, or this particular mutual fund, the owner is, or the heir is supposed to be so and so. And to that extent, on receipt of this particular document, they will transmission that particular bank account, demat account, or the mutual fund to the heir who is the heir under succession law.
Okay, so a follow-up question from that, in the case of a demat account or a mutual fund unit, since the second owner can transact and operate the account in the event that the first owner has passed away, then it is incumbent on that second owner to ensure that the right of ownership is followed, right? If there is a will, then effectively they become like a nominee, right?
Absolutely. You are absolutely right. And I would say the only difference between a nominee and an owner is a nominee is only acting in a capacity of a trustee, while on the other hand, joint owner has ownership rights. So
Yeah.
to that extent, he or she does have a right to deal with the 50% or whatever is the carved out ratio on that particular asset in his own ownership, while a nominee can only act in the interest of the heirs or the person who has nominated him. It's in a way like an agency.
What about physical assets and property? Here's where it gets a little complicated, right?
Yes, absolutely. And when you have like situations of, say, property, it could be an apartment in a building or it could be land. Very, very common, wherein you will just write random family members' name on the property, while in effect, it may be one or two family members who actually contributed to the purchase of the property. Now, not very common for, you in your property document to say whether it is a joint tenancy or a tenancy in common. If it is a joint tenancy, then to that extent, when one of the owners passes away, if you have mentioned that this is a property which has been purchased under joint tenancy, the law will essentially say that it goes to the surviving owners. Very rarely will you actually really write it as joint tenancy. In a situation where you do not write anything, it would be deemed to be tenancy in common, which essentially means that if we have mentioned five persons as the owners to a particular property, and there is no ratio mentioned in the sale document as to what is the ratio between these five, it will be deemed to be equal. And to that extent, assume you have A to E as owners, A owning, say, 20% on an equal proportion. A can, in his or her will, say that my 20% goes to so and so people. Now, it's only in a situation where the other owners or the continuing owners, surviving owners, really dispute that, look, A only was added for convenience, and they actually have documentation to showcase that no money was contributed by him. Even if you look at the rent receipts, the rent has essentially come to, say, BC, or to the balance, it has never come to A. Or for that matter, if there was a housing loan really taken, the housing loan deduction under the Income Tax Act was only taken by the remainder and not by A. And to that extent, the other attributes of ownership have not been proven. Then in that situation, B to E can essentially say that A was only added for convenience, and it's more in the nature of a joint tenancy, wherein A's heirs do not really have any ownership interest.
Yeah,
Now,
interesting.
interesting to note that the law is there and it's very, very clear. However, for you to prove all these points, you will require a lot of documentation in your possession to knock on the doors of the court and say as to whether this person has been added only for convenience, and to prove whether it's a joint tenancy or a tenancy in common.
Yeah, important points that you raise. And so therefore you go back to the original statement of where there is a will, there is a way. You said that on one of my programs in the past, and I think it still holds true. Bijal, thanks so much for taking the time today. Pleasure having you.
Thank you so much.